Welcome back to Swat&Vee Immigration News. Please don't forget to subscribe if you're new to the channel. In this video, we are going to talk about how you can apply for Form I-130 with Provisional Waiver known as Form 601A Provisional Unlawful Presence Waiver. Watch to the end for more understanding and updates. Let's get started. The undocumented spouses and children of U.S. citizens or lawful permanent residents may qualify for obtaining a green card or lawful permanent residence in the United States through the I-601A Provisional Unlawful Presence Waiver. Since March 4th, the U.S. Citizenship and Immigration Services (USCIS) have allowed certain foreign citizens who have entered the country without a visa status or inspection by an immigration official to apply for Provisional Unlawful Presence Waiver, also known as a statewide waiver. Previously, foreign nationals hoping to obtain permanent residency through a citizen relative would have to leave the country and apply for re-entry at the U.S. Embassy in his or her home country. This process was fraught with uncertainty and would separate families for months or even years. Let's know when you should file for a provisional waiver. First and foremost, if you are seeking U.S. residency through an immediate relative who is a U.S. citizen, he or she must file for a Form I-130 on your behalf if you do not already have an approved Form I-130. Sponsoring new immigration. Once the Form I-130 has been approved, you will be able to file for your provisional waiver application. It is also recommended that your U.S. citizen sponsor indicates on the Form I-130 that you intend to apply for your visa from the U.S. Embassy in your home country. This way, the USCIS will automatically transfer your file to the National Visa Center and the U.S. Embassy in your home country after the Form I-130 has been approved. Let's see who is eligible for a provisional waiver. To be eligible for a provisional unlawful presence waiver, you must meet all the following conditions. 1. Must be physically present in the United States. 2. Must be at least 17 years old. 3. The immediate relative of the U.S. citizen, such as a spouse, child over the age of 20, or parents. 4. Your immediate relatives Form I-130 petition was approved. 5. If you have a pending immigrant visa case with the Department of State and paid the immigrant visa application fee. 6. Can demonstrate that your U.S. citizen spouse or parent will suffer some extreme hardship, such as medical, emotional, or financial issues if your waiver is not granted. What are the steps for obtaining Form I-601A Provisional Unlawful Presence Waiver? For a typical case, the steps for obtaining a green card or lawful permanent residence through the Form I-601A Provisional Unlawful Presence Waiver include: at first, file the Form I-130 petition for immigrant visa with U.S. Citizenship and Immigration Services. After the Form I-130 petition is approved, pay the immigrant visa fee with the National Visa Center. Then file the Form I-601A Provisional Unlawful Presence Waiver with the U.S. Citizenship and Immigration Services. After the Form I-601A Provisional Unlawful Presence Waiver is approved, submit the DS-260 and civil documents to the National Visa Center. The National Visa Center will schedule the immigrant visa appointment at U.S. Embassy abroad. The family member attend the visa interview at the U.S. Embassy, and if it approves, the immigrant visa will be placed in the visa stamp in the family member's passport. The family member returns to the U.S. and is admitted as a lawful permanent resident or green card holder. The family member must also pay the USCIS immigrant fee to receive the lawful permanent resident card in the mail. Let's know what are the 3 and 10 years time bars. Without the provisional waiver, foreign citizens that have remained in the U.S. without legal status were at risk of being barred from re-entering the country. For example, in order to apply for an immigrant visa or green card, foreign citizen would have to return to his or her home country and file an application at the overseas embassy. However, depending on how many days the foreign citizen spends in the U.S. unlawfully, he or she would be automatically barred from returning to the U.S. for a number of years. 3 years would be applied when the foreign citizen's spent more than 180 continuous days in the US illegally. If the foreign citizen spent more than 1 year in the US illegally, then the 10 years will be applied. By filing for a provisional waiver, a foreign citizen would find out before leaving the US whether he or she would be allowed to re-enter the country without being barred for several years. Please share this information with family and friends who may need it. You can also help us spread the message by sharing it on social media. Thanks for watching. Please don't forget to hit the notification bell and please subscribe to the channel for more immigration updates. Thank you. Bye.